function of supervisory court. So it is different in function. Their function is not to redo the case. So you're not going to find witnesses. That's not their function. You're not going to find even the parties. That's not their function. Okay? There's not going to be any testimony, any smoking gun. There's not going to be any of that. What they do is that they look at what happened. They don't take into account new stuff. They looked at what happened, and they look at the rules, and they make sure that what happened and the rules kind of work together. I'll give you an example. Who here doesn't know that you have the right to remain silent?
I do.
You have the right to remain silent. If you were approached by a government agent and you're going to be arrested, part of the Miranda rights that everybody knows. You know when somebody's being arrested and they say, I know my rights. Has a third grade education. Just did some dastardly deed. But they know they have rights, because everybody knows they have rights. And among those rights is the right to remain silent. That right is in the Fifth Amendment. Okay? You have the right to remain silent. Your silence cannot be used against you in a court of law. Okay? Now, let's say that the police officer didn't read you your rights, and by the way, in a Supreme Court case called United States versus Arizona, the Supreme Court stated, now it was Arizona versus, Miranda versus Arizona, not United States versus. In Miranda versus Arizona, the court said that when you are arrested, a police officer must read to you these rights. Okay? And therefore, every cop show you've ever seen, when they book somebody, you see somebody reading these rights. But let's say that in the real life world, the police officer forgot. And you got a case of the nervousness, and you got a case of the, I call it diarrhea of the mouth, and you confessed that they never read you your rights. And since you confessed in your trial, guess what? Your words are used against you. And the jury, having heard that you said that you did it, finds you guilty. Your attorney turned red in the face and said to the judge, Judge, you cannot allow this confession because this police officer never read them the Miranda rights. The police officer admits he never read the Miranda rights, but the judge said it doesn't matter. She said, he said that they did it, so they go to jail. And you say, that's not fair because the system says, the Supreme Court says, the law says that if Miranda is not read at the time of an arrest, anything that is said by the defendant procured by an interrogation cannot be used. So the appellate court looks at what happened, looks at the law, and sees if what happened in the law is appropriate. In the case of the confession, what do you think that the appellate court is going to do? It's going to say that confession cannot be used against you. Go back and retry the case without the confession. Because that's what appellate courts do. So now that you know the basic layout of a trial court, let me take you through the basic layout of an appellate court. Because it's completely different. And the actors, and I like to call it acting because I think that what lawyers really do is we're actors. Okay? We're actors or fancy English majors. So if any of you ever wanted to go to law school, I tell you, become an English major. Because there's an awful lot of writing and there's an awful lot of reading. And your tool of the trade is your dialogue and your writing. That's what we do. We're fancy English majors, but saying that you're a lawyer is cool. So, if you go for a job interview and they say, what are you doing? I'm an English major that happens to go to law. It's not as cool as I'm a lawyer, right? So that's why we say we're lawyers. Okay. In an appellate court, you have a much longer, I'm not going to use the word altar, bench. And in that bench, you have, how many judges did you have in the trial court? Just one. Actually, I'm lying to you. You actually have one judge of the law and a whole bunch of judges of the facts. Judges of the facts, we just call them juries. But we never think of them as judges, but they are judges. They're judging what facts are true and what facts are not. But in the appellate court, you have, at the very least, 3 judges. 1, 2, 3. Dressed all in black. Okay? In big, long robes. They look fine. Sometimes you have more than 3. Sometimes you have 9. Supreme Court has 9 justices. Okay? Then you again have the 2 tables. You have a podium, or you have a table where there is a clerk, and you have attorneys. What don't you find here? You don't find the parties. They're usually not in a appellate court. Why? Because what's taking place here is the court is determining whether the law was applied correctly. There's no evidence taking place. Judges don't make determinations as to whether they like or dislike a person. They make determinations as to whether the law was followed correctly. So attorneys, no parties. There is a court reporter. There is a clerk, same function. And there are 3 judges. There is no evidence taken. What is evidence? What somebody saw, some document, the smoking gun, that's evidence. The DNA, like CSI, that's evidence. It doesn't take place at all on the court. What the judges want to know is, tell me what happened and what is the law? Can what happened under the court have taken place? One attorney says, absolutely, it happened correctly, the law is correct, they did everything right. The other attorney, of course, states the other side, no, it can't happen that way, the law says it's wrong, and the judges listen to these legal arguments, and it makes a determination. Generally, they don't decide in a trial. The verdict is read right after the trial. When the jury deliberates, the verdict is read. In an appeal, the attorneys show up to the function. The 3 judges then take it into consideration, and months later sometimes is when they write their opinion. Okay? When they write their opinion. Sometimes we read their opinion, we call them cases. And there are books downstairs called reporters that have a compilation of all of the opinions. Okay? That's what they do here. That's what they do here. Now, there is a final level, the pinnacle. By the way, there are fewer appellate courts than there are trial courts. You know why? Especially in the civil side, if you've lost and spent a lot of money, you may not have a lot of money to spend to take an appeal. I'll give you an anecdote. Oftentimes clients come to me and they want to be hyper aggressive. I want you to do whatever it takes. I want you to be a bulldog. I want you to be as hard as you possibly can and win this case or treat them poorly. That's what the client looks, they want often, especially if they're angry. Then approximately a month later, when they receive my bill, they are no longer as aggressive. They no longer want me to do as much as I'm doing, because they now realize that everything that I do costs them. Okay? So by the time that I get through a trial, and by the way, I bill on an hourly basis to go to trial. That means for every hour, for every minute that I'm there, I'm billing them. Now, I'm a very reasonable in my hourly rates. My hourly rates are anywhere between $175 to $250. I know attorneys in this town that charge $500 an hour. That means for every hour that they take in a case, their client is paying them $500. Cases sometimes take days. I was in a case that took 6 months. We tried it every day. 6 months at $500 an hour. So by the time the case is over, sometimes the client thinks that they're right, thinks something went wrong, but doesn't have the funds to be able to appeal. So there are fewer appeals than there are trials. Now, the Supreme Court, both in the state of Florida and in the United States, is a court that you can only get to if they allow you to. I'll say that again. You can only get to the Supreme Court if they allow you to. The Constitution only says that there's a couple of cases that are automatic. Let's say that it involves dignitaries, consulates of different different countries, yes, it'll go to the Supreme Court. But you and I have this great case, and the appellate court did us wrong. They were wrong. And we want to appeal to the Supreme Court, because the Supreme Court doesn't want to hear our appeals. Guess what? They won't hear our appeals. Okay? So the Supreme Court is said to be a court of limited or restricted jurisdiction. Okay? How do you get to them? You send them a letter and say, please, pretty please, this is an important case. You need to do something about it. And then they sit together, true fact, they sit together with all of those petitions that come in. Okay? This is called a petition for writ of certiorari. But that's what it's called. And the judges sit there and they read the petition amongst themselves. And then they take a crude, rudimentary vote. What do you think? We should take it? No. What do you think? We should take it? No. What do you? Yes, yes. If they have I think it's a simple majority, then they take the case. If all of them say, yeah, it's a good case, but you know, it's kind of boring, we don't want to waste our time, they don't take it. They don't take it. Now, there are cases that are more likely to be taken than others. Let's say that it's a case that involves a very important political issue, Obamacare. Okay? The court could say, we're not going to listen to it. And they don't have to. But because it's such an important political issue, they might say, we need to rule on this. And they did. By the way, I lost on my analysis as to what the court was going to do. I honestly thought that it was going to be found to be unconstitutional. Remember, federal government can only do those 17 things. And none of those 17 things says that they could mandate health care. But the court was smarter than I and says it's not health care. No. Obamacare is not health care. It's tax. And what happens is Obamacare says, look, government can tax you. It can also say to you, I'm not going to collect your tax. I'm the government, and you owe me money, but I'm not going to collect it. So every citizen of the United States owes money to the government. But they can do something to avoid paying that money to the government. And what they can do to avoid paying that money to the government is having health care. If you can prove to the government you have health care, they take that tax away. So the Supreme Court said it's not the power to mandate health care, it's the power to tax. I didn't see it that way, but they were a lot smarter than I was, and they found it that way. So important political cases, like who wins the elections, they might take. Cases where a federal court in California says yes, and a federal court in New York says no, they might take because they don't want the laws in different areas in the United States to be different. They want all the law in the land to be the same. I'll give you an example. The California court decided for a long time that you couldn't say the Pledge of Allegiance. Can't say the Pledge of Allegiance. You're going to say, well, why? Well, if you remember the simple words of the Pledge of Allegiance, it says that we are one nation under God. Remember when we were talking at the very beginning of this class about the freedom of religion. Okay. So, generally it's been interpreted to be freedom from religion. Mentioning God is a religious thing, right? Would we agree that mentioning God is more religious than anything else? So, because the Pledge of Allegiance is an official government act, when you're saying the Pledge of Allegiance, what are you saying to the United States? I'm going to be loyal and faithful to you as a nation above all other nations. Because it's an official government act that you're doing. Mentioning God, the court in California says, is unconstitutional. So you can't have citizens utilizing the word under God in the Pledge of Allegiance. Courts in the East Coast said, what are you talking about? What are you talking about? God is not Jehovah, it's not Allah, it's not Buddha, it's just a generic name, God. Are we really that ridiculous that the mention of the word God is going to be found unconstitutional? So that's what the court over here says. Can't say it, can't say it. Supreme Court took up that case because two different courts had argued and come up with different solutions. And ultimately decided, I think probably economically so, that the mention of God was more a traditional mention. In other words, we weren't really saying, you know, go to church and pray. We're just using God as a generic term. And the reason that I say that it was economic